Ladies and gentlemen, the American jury and Bulldog Nation, welcome to the next episode of Eric Deters, The Law, where I give you an educational lecture off the top of my head with a few words on an outline so you understand these issues. By the way, I'm getting great feedback from this. I had some individuals contact me and they say, when are you going to just do a school? And I said, you know what? After I do all these series, I think I might do a school, not to mention a book, because we can get all of these transcribed. And I got a book about general law for the public. So let's talk about contracts. I got a great little quote for you to start out. Will Rogers once said, when two people are meeting, a deal is going down. And you think about that, he was a humorist, but when you think about that, it's true. Every time you encounter somebody during the course of your day, there's some kind of deal going down. You're just being nice to each other. That's kind of like a deal, isn't it? Now, contract law. This is hysterical. It is a whole semester in law school. It's called contracts. And then it's a big part of the bar that you take, the bar exam you take. And they have these seminars where you study. After you graduate, you study. You have this book and you watch these lectures. And there was this one cool dude, lecturer contracts, where he developed, like he was talking really fast, where he says, I can give you all the law and contracts. And he just starts talking. A contract of blah, 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 and da-da-da-da-da. And it was really good. Now, I'm not going to talk fast, but I am going to explain contracts law so you can understand it. And unlike these conceited, arrogant, narcissistic lawyers, I'm somebody who recognizes every single day who would really be a good lawyer. They can be. I can tell you right now, the staff at my law firm, by golly, those ladies would be incredibly good lawyers. Sabrina Kane, maybe not, but the others, just teasing Sabrina. Now, here we go. Anything can be agreed to. You can create a contract about anything in the world as long as it's not illegal. So a contract to transport cocaine through Utah is an illegal contract. You can't enforce that contract. In the most simplest of terms, here's what a contract is. An offer to do something, provide something, whatever, an offer. An acceptance of that offer. Now, very important, before the offer is accepted, the offer can be withdrawn. If the offer is withdrawn before there is an acceptance, there's no deal. All these things that I'm going to talk to you about is where you have litigation. You know, was the offer, what was the offer? Did the offer get changed? Counter offers. See, you form a contract. Consideration. There has to be some consideration, something that passes hands, usually money, but it could be anything. It could be just some great benefit to an individual. Offer, acceptance, consideration, mutual consent. We call it a coming together, a meeting of the minds. That's what you got to have. If you have all that, you got a contract. Now, you also have to have mental capacity for a contract. If you have Alzheimer's and Parkinson's that's so bad you can't enter a contract, you've got a brain injury, this comes up all the time, usually in these estate situations where you prepare a will. A will is kind of like a contract, but you prepare something and you have to decide whether or not how bad the Parkinson was. For example, if you're trying to get out of a contract because somebody had Parkinson and Alzheimer's, you ready for this? You have to prove that they had it at the time they entered that contract, because a lot of times you have these intermediate periods where you're okay, but you got to have capacity. A breach of a contract means you did not fulfill one of the conditions of the contract. Folks, sometimes there's one condition. You're paying me $100 and I am delivering to you a load of firewood. It's a contract. Now, the contract conditions can be long. You get these big law firms involved, by golly, they throw in standard language, boilerplate, legalese crap that's really, really long. A promissory note to a bank, law. And I got a maxim. If it's really complicated and you can't understand it, it's bad for you. Plain and simple. And see, these lawyers throw in all this complicated crap to make themselves justifiable. I learned this from my dad a long time ago. I can't tell you how many contracts I've drafted on a legal pad and said, boom, 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 I sign, you sign contract. Or type up a little simple form. It's that simple. All right. A breach of the contract is when you do not fulfill a condition. Now, this is a pretty cool thing. And this is my theory of liability against Facebook that I'm going to try. Promissory estoppel or detrimental reliance is this. I make a promise to Chuck. Okay? We never enter into a formal contract, but I make a promise to Chuck that, hey, Chuck, I'm going to show up at your house at noon on Saturday with $10,000 for your car, as long as it's all clean. Chuck relies upon my promise that I'm going to show up with $10,000 to get his clean car, and he cleans it all up and has it ready, and I don't show up. There's no written contract. He relied upon it. It's called promissory estoppel or detrimental reliance. He relied to his detriment on something I represented that a rational person would, and I didn't follow through. Now, what I just described might not be an enforceable contract for another reason, but we'll talk about that in a little bit. All right. Real estate. When you are involved in real estate, this comes up all the time in the everyday world. I'm going to help you out. You'll never have to ask a lawyer about it and spend money on a lawyer. No matter what somebody promises you. Chuck says, Eric, I'll sell you my house for 20 grand. Deal. Whatever in real estate, if it's not in writing, it's not enforceable. All real estate contracts have to be in writing. And it's called we're going to talk about in a minute. Same thing with a lot of business contracts. A lot of business contracts sometimes got to be in writing. Now, statute of frauds. To be honest with you, folks, it's not a statute. Really. It's really common law, although most states do have the statute, which a statute is a law passed by the legislature, and it really doesn't have anything to do with frauds. But a statute of frauds in each state is a set of circumstances where you have to have a contract in writing. Real estate, if the amount involves a certain amount of money, larger sums of money, it has to be in writing. It's called the statute of frauds. Undue influences. You know what? If I'm doing a deal with Chuck and Chuck has his best buddy with a gun to my head saying, sign the contract, Bulldog. And I had a camera that showed that contract's not enforceable. It was under undue influence. All right, damages. Damages in the contract are pretty simple. Whatever flowed from the breach. You know, Chuck spent $200 getting the car cleaned by Top Shine and chased Oberst Flint. By golly, I got to pay him that because that's out of his pocket. But just use anything that directly and indirectly, rationally flows from that breach is your damages. Compensatory damages. Now, a lot of contracts, this is very important. A contract is evaluated by its four corners, they say. What's in the contract? Again, you could put anything in that contract. You know what's in a lot of contracts? Whoever breaches the contract, if they lose in court, has to pay the other side's attorney fees and court costs. See, if it wasn't in the contract, you wouldn't have to do that. So you load up the contract with all kinds of conditions. Some sneaky son of a guns throw in stuff, fine print, where you least expect it. You know, got to read that contract with a fine-tooth comb if you don't trust somebody. All right, punitive damages. You've heard about this in other litigation. Those are damages to punish you. You don't get those in contract law. Well established all across the country, you cannot get punitive damages for a breach of contract. illegality. I can't contract with, making up some crazy stuff, Jane's House of Prostitution. I can't sign a contract for a prostitute every month at noon on Wednesday. Why? Because it's illegal. Okay? You can't do a contract. You can do one, but it's not enforceable. The most important thing when you're doing a deal with somebody is plain and simple and clear. A good lawyer, like I was before I retired, and I still am, I just don't have my license to practice it, writes things nice and simple. This is hysterical. In my job that I do a lot of legal drafting and research and whatnot. And I actually train others that help us in this cause. I recently helped train somebody who would write like this. Herein, therefore, the party of the first part and the party of the third part, blah, blah, leave all that out. I, Eric Deters, hereby agree to use Sabrina Kane's photography services for my bar mitzvah. All right? Simple. Simple. By the way, I'm not Jewish, but I got a lot of Jewish friends. By the way, my good buddy Larry Forkey always referred to him, Chuck, as Hebrews. He didn't say it in a negative manner. He's Hebrews. All right. Void. If something, one of those conditions or undue influence, you void the contract. Unjust enrichment. Unjust enrichment is you may or may not have a contract, but you've been unjust. You benefited from that contract. You have to pay for it. That's also called quantum meruit. All right. Contracts can be oral. If subject to the statute of frauds. If I shake hands with Sabrina Kane that she supplies photography services for my 61st birthday next year, and we shake hands and she says, I'll do it for $1 because it's for you, and we shake hands on it, I could enforce that contract. Handshakes can be contracts. Gratuitous. You can't enforce gratuitous stuff. This happens all the time because you see somebody famous say, well, by golly, I will give him my house if they win this game. That's gratuitous. You can't enforce it. Interpretation of the contract. It always comes down to interpretation of words. That's why it's important to be simple and clear. By the way, the court system interprets the contract against the person who drafted it. In other words, if it's a close call and they got to make a decision, they side with the person who did not draft the contract, what something means. I've already covered complicated, forget about that. Terms of the contract, same as conditions. You can load it up with all the terms you want. You can put in a contract. Let's say it's a contract to buy a house. You could put in that contract, I want this, let's say you're buying it. I want the seller to deliver me a birthday cake on my birthday for the rest of my life. They agreed to it. They got to do it. Arbitration. More and more in contracts, especially employment contracts, they put in what's called arbitration mediation clauses, where you're giving up your right to go to court for a jury trial. Although I can tell you right now, in contract law, generally jury trials are a waste of time anyway. Then, of course, you got an option. You can file an action for court. These would be in common pleas in Ohio, generally, unless they're really small things, and circuit court in Kentucky. The mailbox rule. I just thought I'd throw in this for fun. Remember that offer and acceptance back and forth that I talked to you about? It gets real complicated if you have like offers going through and they're accepted by mail, but the acceptance wasn't delivered, but it was placed in the mail. Crazy stuff. Specific performance. Along with your damages, you can also sue for specific performance. In other words, I signed that contract for Sabrina to supply me with photography services, and she tells me, by the way, here's another expression, anticipatory breach. She says, Eric, I'm not going to be able to do that. I can sue her and get an order where she has to do it. Specific performance. Withdrawal of an offer. At any given time before the offer is accepted, you can withdraw it. So there you have it. I'm sure I left something out, But that gives you a good overview. If you've got any issues with a contract, you can email me at eric@ericdeters.com or text me 859-250-2527. Remember, this is not legal advice. It's strictly educational. It's 100% free. And just like your neighbor's allowed to give you advice, so can I, as long as I don't charge you money. So if it's a simple little question, and you're my buddy and pal, friend of mine, you text me and email me, and I can save you a lot of money by giving you a quick answer for free. That's part of my goal in these series. Part of my goal is to put a dent in the legal profession's attorney fees by virtue of the fact that if you watch some of these, you won't need to contact and pay a lawyer as much as you maybe normally would. I want to educate the public about law. This is the Bulldog. Every dog has their day. You have a great one.